of contact or communication with his child. I understand if the court believes that he did something wrong, but Judge, I don't know that his actions went to the extent that he has to be cut off completely from this little girl and not be able to talk to her or see her at all. We are asking, Judge, in the interest of justice, and because the rules do allow you to grant a new trial for good cause, that not only that you grant the new trial, Judge, but that you...
The motion for new trial that has been set for today, there's been an objection filed, and Attorney Espinosa, I will allow you to go ahead and make your argument for that.
Your Honor, I did prepare a detailed argument of the case. I think this case involves a little bit of convoluted factual history regarding some actions that the party, particularly the father, took in this case. So I know the motion, my written motion is more detailed, but I would ask that you take judicial notice of it. However, it is our contention that this motion for new trial should be denied for several reasons. We believe that it was not timely filed. This case was ruled, the order in this case was signed on August 28th. And on that same day, the court coordinator sent notification by email to both sides that the final order was signed. So we contend that the court's plenary power started to run effective that day, and the time to file a motion for new trial. In this case, the father filed his motion for new trial on October 25th. We contend that that is untimely. That's outside of the 30-day period that's prescribed by 329B of the Texas Rules of Civil Procedure. And we do not believe that any other exclusion applies or to allow the filing outside of 30 days after the entry and signature of that order. We do believe that the court properly notified both sides, in actuality sending them a copy of the order by email to them for them to sufficiently know that the order was entered. If the court goes beyond that analysis, we believe that this motion for new trial should further be denied for failure to establish the Craddock elements that are required in a motion for new trial. We believe that the father is complaining. The father's list of complaints are not very specific in the motion for new trial. It's just a litany of let's see what sticks and let's see what might work. And we believe that their motion to modify is not specific enough to give mom notice on exactly what they're challenging on the motion for new trial. I would contend, Your Honor, that this case was properly scheduled, was properly heard on final trial on June 21st of 2023. Father complains that he did not have time to hire an attorney. We believe that the court followed procedure. Father requested a motion for new trial at the time of the trial setting, and the court denied his motion for new trial for failing to follow the proper procedure in giving notice to parties and setting a hearing on a motion for new trial on the day of trial. Asking for a continuance on the day of trial was not the timely procedure, and the court is obligated to hold parties to the same standard, whether they have attorney or whether they don't have an attorney. Any attorney who would not have given proper notice would probably have not been heard on a motion for new trial on the day of trial. Further, we also contend that we see that father makes an argument that there's newly discovered evidence that he wants to bring into this case. We believe that that is an improper way. That's not one of the prongs that are required in a motion for new trial. I'm sorry, in regards to the Craddock rules, they have not filed it timely. They have not complained specifically about what is wrong with the judgment. We contend that Father does not have a meritorious defense in this case. Father complains that he doesn't have access to the child based on the orders. However, if the court recalls, this is a case regarding a father that took the child out of the country, kidnapped the child in violation of the court's orders in Texas. So the court did leave some visitation plan in place for the father to be able to see the child on Tuesdays and Thursdays, following the first and third weekends of each month. That order was rendered in June. To this date, Father has not made an effort to exercise the supervised visitation as ordered and as established. In addition, the third element that they have failed to establish, Your Honor, they're contending that granting the father a motion for new trial will not injure the mother. In this case, there is definite injury that would be inflicted on the client. As the court recalls, this case involved an extensive enforcement case and recovery of a child that was taken to Mexico. At one point, Father was ordered to pay a judgment of $21,857.78 that was due on March 29, 2023. To date, the father has not paid that. In addition, at final trial, Father was ordered to pay a security bond of $30,000 due on October 1st of 2023. To date, Father has not paid any of that either. In addition, Father was ordered to pay $9,369.50 for attorney's fees that mother incurred in having to defend and protect and find this child from Mexico. And so Father was supposed to pay that amount on or before July 31st of 2023. Father has not paid any of that. So we believe that granting Father a motion for new trial would definitely injure the mother financially, because she has incurred all these expenses, and it's important for her to have an order in place so that she can feel protected and so that the child can feel protected. And the order does provide sufficient orders for the father to have access to the child. We believe that this was a case of international kidnapping, as evidenced by the father's own actions. And so we do not believe that he should be granted the opportunity to hide behind a motion for new trial to try to reopen this case and to try to relitigate these issues when the day of trial was held on June 21st. We believe that this is a backdoor attempt of Father in trying to bring in newly discovered evidence. However, we contend that he's trying to use newly discovered evidence that was in his control, on his side, through his lawyer. So newly discovered evidence is not an element of the Craddock test. It's not an element in a motion for new trial. And we believe newly discovered evidence, maybe that's an issue for a modification in the future. However, newly discovered evidence is not a standard that should be applied in this case. We believe that discovery closed, evidence was heard, evidence was closed. Granting a motion for new trial on newly discovered evidence would be improper. We believe that the current orders that are in place are in the best interest of the child, for the protection of the child, to prevent international kidnapping and further instability for the child and for this family. We did ask for attorney's fees. I don't know if at this point I can make my request for attorney's fees.
You can go ahead.
Your Honor, client is asking for $2,500 in attorney's fees and having to hire me at the last minute to defend this case again. I'm an attorney in Dallas County. I've been practicing for more than 20 years. I practice primarily in family law. My hourly rate is $350 an hour. I charged this client a flat fee of $2,500, hoping that that would be sufficient to cover the time for today's hearing. We estimated that to date, including 1 hour of trial for today, would be just 7.5 hours, and that comes out to a total of $2,500. I did spend extensive time reviewing this file because there's extensive factual history regarding prior order, the enforcement order, the Mexican proceedings, the final trial, the evidence in trial, and then the documents that were provided by counsel today on their motion for new trial. So we're asking that the court, for all reasons, whether it's for lack of plenary power or for lack of meeting the Craddock test, we ask that the court deny father's request for a new trial.
Thank you, counsel. Attorney Olvera?
Judge, starting off with your objection about the timeliness, as you know, Judge, there is a provision in the Texas Rules of Civil Procedure under 306A4 that extends out the deadlines for the filing of a motion for new trial. And that is if the party does not receive notice of the final judgment within 20 days of the judgment being signed. Now, I understand that counsel has provided you a copy of an email from Destiny McGinnis where she was sending out, notices to the parties of a judgment. But my client has sworn out an affidavit, as he is required by the Texas Rules of Civil Procedure, stating that he did not receive that notice. I believe, Judge, when all of this was going on, there was some confusion about whether his email was at Hotmail or Yahoo, and some of the emails were going to the wrong email address. So he never got that notice. We put in our motion, Judge, when he received actual notice of the order, which was on September the 25th. And according to the rules, it says that if he receives notice after the 20th day, then his deadlines start running on the day that he finds out about the order, which was September the 25th. So his deadline to file the new trial was on October the 25th, which is what we did, Judge. And we followed the rules, and we provided also, Judge, today as an exhibit, an email that he had received advising him that the case was set for dismissal sometime in September, and he never got anything else after that. Now, my client, if you allow him to testify, is going to say that he was going up to the courthouse, him and his sister, checking on the status of the order and looking for the order to see if it had been signed. And he went down there several times, Judge, and each time they told him that there was no order. I don't know if there was some delay in uploading it to the file or what happened, Judge. But as you know, that happens sometimes. There are some delays with it getting uploaded. And if he went down there and looked for it, he exercised due diligence in trying to find out whether this order had been signed or not. So aside from that, Judge, Ms. Espinosa argues to you that we failed to plead the elements of a Craddock test. The Craddock test is not applicable in this case. The Craddock test has to do when it's a default judgment, and it contains 3 elements. The fact that he would have a meritorious defense, that there would be no injury to the other party, and that he's willing to pay some attorney's fees to get the default removed or set aside. This is not the case because it was not a default, Judge. This will proceed under the TRCP 320 that clearly says that a court, whether it's on its own motion or on the motion of a party, can set aside a judgment and grant a new trial for good cause. So what that says, Judge, is that it is within your discretion if you think there is enough of a reason to go ahead and grant the new trial. Now, the rule right after that gives you a list of the different things, including newly discovered evidence, some kind of error in the judgment, and it lists about 5 or 6 different grounds that you can plead in a motion for new trial, but they are not required, Judge. You are only required to plead that if you are going to appeal, because if you appeal on those grounds, you had to have filed your motion for new trial on those grounds. We went ahead and we stated those grounds to be on the safe side, and also because there are newly discovered evidence and some other things that I believe not error necessarily on the court's part, Judge, but the information that the mother brought about in the trial. So, not arguing the Craddock test because it does not apply in this case. What happened in this case, Judge, is the child went to Mexico to visit dad by a mutual agreement. Mom says that dad refused to return the child on July the 1st. And then she says that she went and swore out a police report on the 6th after they had a telephone conversation. But in actuality, my client was not required to return the child until July the 27th, per the court order that she got entered by this court. Judge, the other thing that the final order says is that she is required to pick up the child from my client at his residence. That's what the final divorce decree said. Now, I know that there was a lot of back and forth, and there's a criminal charge that is pending with my client because of this incident, Judge. But what Mom failed to tell you in the trial was that when she went down there to Mexico, she did initiate the Hague Convention case. And in the middle of that, before it was finished, she grabbed the child and came back to Texas. That is the reason that this red alert was sent out by Interpol. The red alert is not necessarily a warrant for her arrest. It's just an alert that they set out just because somebody has left the country, and those people, those officials, either law enforcement or the court, has asked Interpol to do the red flag or the red alert. Now, I know Mom accused Dad of doing that and of Dad filing it. He is incapable of doing that, Judge. And I provided as an exhibit the stuff directly off of the internet website of Interpol that says how a red alert gets issued. And it says it's issued at the request of law enforcement or court authority. It was not my client. He is not capable of doing that. But in either case, Judge, with whatever happened over there in Mexico, she brought back the child. And we are not disputing that you are the one that has the jurisdiction to make the determination of custody and visitation for this child. The only thing that we're disputing, Judge, is that Mom did not give you all of the information. So what she had testified, Judge, was that my client did not have any contact with this child, had not seen her in years, had not really visited according to the order. But what she fails to tell you is that in that hearing or in that proceeding that was going on in Mexico with the Hague Convention, that court ordered an interview of the child by a psychologist in Mexico. And that psychologist...
Honor, I would object to proceedings that occurred in the Mexico court. They don't have jurisdiction over this child.
I'm not saying... Judge, I'm not saying that they have jurisdiction over this child. I agree that your court has jurisdiction. But the reason that I'm arguing that is because it is the newly discovered evidence. And second of all, Mom failed to tell you about it. The fact that this child had been interviewed and a report had been provided to the court regarding the allegations of abuse. And that before that part was concluded, she came back to Texas. That is the newly discovered evidence, Judge. It is a report from the psychologist, which I have, but we didn't get it in time to be able to translate it and to produce it or file it with this court, because there are deadlines by when we have to file it, and we have to file it with a certified translation. And I believe it's 45 days before the hearing. So that was somewhat of an impossibility since we just filed the motion about 30 days ago, Judge. So that is the newly discovered evidence. If there is some evidence, Judge, and there are allegations of family violence or some kind of abuse of a child, I know that the court's first priority is always to ensure the best interest of the child and to do what's right for this child. And that's why we're asking the court to reopen the case and look into these allegations, because those allegations were made to the court in Mexico, and they thought of it serious enough that they are the ones that asked Interpol to issue the red alert because they had some concerns about this child. And anyway, Judge, according to the mom, she has been taking the child to a counselor. We don't know what counselor. We don't know how long she's been seeing them, but she didn't give you any kind of information at the trial about what's come out of the counseling, what the child has said to the counselor, what is going on with that counseling. The only thing you heard at the trial was her version. And that's what I find a little bit suspicious. You heard her version. She came on, she told you about all of these things that the child had said to her, about things that had happened in Mexico, about things that she had seen online, about some contact or some communication between her and the father. Her attorney opened the door wide open on hearsay, unauthenticated documents, everything, Judge. He talked about these allegations very specifically about what the child had said to the mother. And the mother testified that the child had been coached, that the dad had tried to entice the child, that the dad had tried to say things to the child to convince her to stay with him. But she never produced anything in writing, no concrete evidence that would back her up. She didn't even produce the records of her own counselor, the counselor that she hired to see the child, and that my client has no access to. So when my client got on the stand, and as you know, Judge, he went to the trial by himself because unexpectedly his attorney withdraws. His attorney withdraws or files his motion to withdraw April the 24th and gets his order signed on May the 5th, about 6 weeks before trial. Did George try to hire a new attorney to get ready for trial? Yes, he did. And I can tell you that because he tried to ask me to represent him in the trial, but I told him there wasn't enough time for me to get ready. So he had no other choice, Judge, but to appear in front of you pro se. He did not know how to admit evidence. He didn't know how to call his witnesses. He didn't even know how to object to the things that they were saying, and he didn't know how to respond to the objections. And even though Mr. Hernandez, who was Ms. Ayala's attorney at the time, went into all the hearsay information about the child, about CPS, about the proceedings in Mexico, he objected each and every time my client tried to bring up the statements that the child said to him and to his family. And I understand why the court sustained those objections as to hearsay. And my client didn't know how to respond to that. But the court has the ability to hear those statements. Under the Texas Family Code, it allows the court to admit statements of a child 12 years or younger when they are outcry statements about abuse or neglect, if there is enough evidence to show the credibility of the child. No one here, not mom, not dad, said that this child lied or that she made any untruthful statements about anything else. So there was an ability for him to testify about the child's statements to him and to his family. So I say all of those things, Judge, so that you will know where my client is coming from a little bit. I understand that maybe he could have chose to do things a little bit differently, Judge, but at the same time, he was acting out of his concern as a father for the child. He came to the trial. He did not avoid you. He has not avoided the criminal court. He has done everything that he is supposed to do. And I understand also that you were given information supposedly about Mr. Rios trying to violate the no contact order. But the other exhibits that I sent in for today show, Judge, that he didn't have any information that he couldn't contact Miss Ayala or the child when he got released from jail. What it shows is that the docket entry on January the 3rd simply says no contact, stay away. And it just says by agreement. It does not say whether he has to stay away from the child or from the mother. And the other thing that I will point out is that he was incarcerated on January the 3rd. He didn't get out until January the 6th or the 7th because that's when he made bond. So he was not in court on the 3rd. Now, after Miss Ayala complained about the contact, then he went into court and he was admonished by the court to stay away from her and the child in April of this year. And since then, he has followed all the provisions of the criminal court. He has shown up to every single hearing. He has kept up with his bond. He has done everything that this court has told him not to do. In other words, don't contact the mother, don't contact the child. He has stayed away, Judge, to obey your orders. But at this point where we're at today, we are at the end of November. He has had no contact with his child, no visitation.
Here's where the defense shifts from arguing procedure to arguing fairness. Their position is simple. Even if the father made mistakes, has the court created a situation where rebuilding a relationship with his child is practically impossible? And viewers, this is where family court cases get incredibly complicated. How do you balance protecting a child while also preserving a parent's right to maintain contact?
No telephone calls since the beginning of November of last year when mom took the child from Mexico and brought her back to Texas. He has had no contact with her. He doesn't know how she's doing. He doesn't know if she's safe. He doesn't know anything about her at this point. Now, Mrs. Finosa says, well, he has an avenue to be able to have contact with the child. Yes, in a way, but the way that the avenue was structured by Miss Ayala's attorney, it is almost an impossibility for my client. Because not only is he supposed to pay all these judgments of $21,000 and then another $9,000, he's supposed to post a bond of $30,000 before he can start his visitation. My client does not have $30,000. And why that was necessary, I don't know, because they requested and you ordered supervised visitation at the FLP Center, where it is a secure facility where he is going to go and see the child there, and he cannot take the child from there. And they didn't offer you any kind of evidence that since being back in Texas, that he has tried to take the child or gone over to try to see the child in violation of your order. They didn't offer anything to show that he has tried to go back to Mexico. What he testified at trial was that he was here for the foreseeable future and that he couldn't leave because of his criminal case. And if you order him to stay here, Judge, so long as he gets to see his daughter, that's what he's going to do. But right now, the way that the order is, it creates an impossibility for him to have any kind of contact or communication with his child. I understand if the court believes that he did something wrong, but Judge, I don't know that his actions went to the extent that he has to be cut off completely from this little girl and not be able to talk to her or see her at all. We are asking, Judge, in the interest of justice, and because the rules do allow you to grant a new trial for good cause, that not only that you grant the new trial, Judge, but that you...
This may be the emotional centerpiece of the entire argument. Notice what the attorney is doing. He's moving away from technical legal rules and focusing on the human element. Judges hear legal arguments every day, but arguments about a parent being completely cut off from a child can carry serious emotional weight. The question is, Will it be enough to overcome the court's concerns about what happened in Mexico?
Order family court services to look into these allegations and order a child custody evaluation so that it can really be seen what is going on, or investigated what is going on in mom's house. And in the middle of all of that, they're going to look into dad's household too and see if he has a good household where the child can visit, if he poses any kind of danger to this child, and if he poses any kind of flight risk. Mom came in and testified to you that she was a victim of family violence and that he's very aggressive and everything. Yet she ended up defaulting him at the divorce judge, and she did not put him on any kind of supervised visitation. She, in that order that she prepared, because she was working for her attorney who did her divorce, in the order that she prepared, she gave him standard visitation. And then she says that he kind of dropped off and stopped seeing the child, but then she turns around and sends the child to Mexico to see dad and to go spend an extended period of time with him in Mexico. That doesn't sound like a parent that is concerned that my client is violent and is going to be aggressive or hurt this child. That sounds like a mom who realizes that the child has a good relationship with dad. But then she says the child hasn't had any contact, but according to her, my client has so much influence over this little 8-year-old that he hasn't seen in 2 years, that in 2 weeks' time, he can convince her to make allegations of abuse against Miss Ayala and her stepfather. That doesn't seem reasonable, Judge, and there is something there, and that is why we're asking the court to order a new trial.
Thank you. Counsel, what is your client's email address?
My client, Mr. Rios, can you unmute?
Yes, ma'am, Your Honor.
What is your email address?
It is my first name dot last name 75@yahoo.com. Jorge.rios75@yahoo.com.
Do you still live at the Mansfield address?
Yes, Your Honor.
Plot twist. After nearly 30 minutes of arguments about custody, visitation, Mexico, and alleged missing evidence, the judge suddenly zeroes in on something much simpler, an email address. Why? Because if the father truly never received notice of the judgment, that could affect whether his motion was filed on time. Watch closely. This final exchange is about to determine whether the entire case gets reopened or ends right here.
Okay, the reason I ask is because any other notification that the court has on file, you've been participating, but yet you said you didn't get notice. I'm trying to figure out how that was possible.
Yes, Your Honor. The last time we had a court via Zoom with Judge Lee, the secretary there, when I told him that I wasn't getting any notifications, and she told me they've been emailed to me. I asked them what email they had for me, and they had a wrong email. They had jorge.rio75@hotmail.com. They updated it now, but that is the reason why I didn't get notified.
Your Honor, if I may add.
Go ahead.
I did read the transcript today, and I think the transcript is abundantly clear. The procedure was followed. The rules of evidence were followed. In terms of what was admitted to court, it's not mom's attorney's job to present Mr. Rios's case or to present his evidence. So I don't know why that is being put on mom or mom's attorney. I believe they presented evidence before the court properly, as they could have and should have. If you look at the trial transcript, the very last question about the emails, if I may.
Counsel, we're not going to go into that. I asked that for a different reason. The court is going to deny the request to open for the motion for new trial.
Okay.
Thank you all.
Thank you, Judge.
Thank you.
You're welcome.
Thank you, Your Honor.